Welcome back to the Crypto's Key Conversation. Hey, so we've been through a lot in the past 48 hours. So just in regards in the markets, obviously there's a lot of different narratives going on with, you have Russian-Ukraine issues, you got stuff going on with inflation, Jerome Powell and the Fed in the U.S., and then Canada has its trucker blockades and the suppression of assets, and there's a lot of different negative narratives going on that's been kind of suppressing the markets. Obviously yesterday we covered how we were in the $34,000 range. Now we're sitting at $39,000 in Bitcoin, and we're up 10%. So we're sitting at a $1.83 trillion market cap. XRP even took a dip into the 60s. Now we're sitting at 71 cents, currently up 10% for the day. Coming over here to the Bitcoin Fear and Greed Index, we're up 4 points from yesterday. We were just at a 23. So obviously there's a little bit more optimism within the upside that we're seeing in the markets. So the topics of discussion is James K. Filan's tweet here about says the SEC has filed its opposition to Brad Garlinghouse's motion to compel turnover of notes taken by Matthew Esterbrook, counsel to the then SEC Commissioner Roisman. A 2018 meeting between Roisman and Garlinghouse. He says the SEC has submitted the notes to Magistrate Judge Netburn for an in-camera review. So obviously that's an update of kind of what's going on around. Judge Netburn's going to take a look at the documents for herself in an in-camera review. Jeremy Hogan had a response to this. He says, "I don't think the judge orders those notes be produced. The SEC does a good job of laying out its arguments in the first part, and I think the second and third arguments are particularly compelling. If the SEC wins the motion, remember it's a small battle in this litigation." So coming down here, Johnny Deaton says Jeremy is on point as usual because Brad Garlinghouse was at the meeting. He is aware of what was said and discussed. Judge Netburn already ruled Ripple could not have the notes from the other meetings Garlinghouse or SBI. It's the largest shareholder were present for. So this person, really rich, says, yet she tells the SEC to give up documents and emails to Ripple, and they still won't give it up. It's beyond annoying that we aren't. And any obvious consequences to IC, a normal litigant would have definitely been in trouble. So coming down here, it says this very blessed person says, "Hey Jeremy, what's next? What's the next step after the judge ruling on the notes to be produced or not? And any updates to keep an eye on?" So Jeremy says, "I'm waiting on for Judge Torres to rule on the motions to strike. Those are the next big rulings, especially for the fair notice offense. I expect those within weeks." There's also the motion for reconsideration on the human emails. Judge Netburn has to rule on those, has to rule on that next month. So obviously things are in motion, and with the in-camera review from Judge Sarah Netburn, and obviously this is Jeremy Hogan's take on kind of the judge is not going to order the notes be produced because Garlinghouse was there, but there's some stuff that's going to be coming within the next week. So just like Jeremy Hogan said, and I want to say a couple of weeks ago, he says the next couple of months are going to be kind of heating up within this SEC case. So coming over here, Johnny Deaton has a huge thread right here that he just put up today. He says huge exculpatory evidence that the August 2018 meeting between Clayton and Hinman with Brad Garlinghouse and Joel Katz. The meetings is 2.5 months after the Hinman speech declaring Bitcoin and Ethereum not securities. Frustrated that only 2 out of the top 3 cryptocurrencies were provided regulatory clarity, Garlinghouse and Schwartz asked what they could do to achieve similar clarity for XRP, with Garlinghouse declaring Ripple is living in purgatory because of the lack of clarity regarding XRP. After the moment, if Clayton and Hinman truly believed XRP was a security, they would have informed Garlinghouse and Schwartz right then and there. Instead, Clayton responded, the meeting was not the proper forum for a discussion about that topic. Neither Clayton nor Hinman informed Garlinghouse that XRP was security instead of Clayton. Hold on 1 second, I got to check on this. So I had to check on my little guy there. So it says, neither Clayton nor Hinman informed Garlinghouse that XRP was a security instead of Clayton. It says, then asked Garlinghouse to back up from that issue and steered the meeting to a discussion about Ripple's business and technology. In fact, at the end of August 2018 meeting, Clayton encouraged the Ripple executive to continue ongoing discussions with the staff, the Division of Corporation Finance. At no time during that meeting did Clayton or Hinman or any other SEC official indicate that ongoing sales of XRP in August 2018 were securities. And remember, the SEC had conducted a Howey analysis of XRP dated June 13, 2018. If the memo concluded XRP was a security, Clayton and Hinman would have informed Garlinghouse that XRP was in fact a security and would have told him to stop selling it without registration. Registration. It says the truth is the first time Ripple or its executives are informed that the SEC considers XRP a security is 2 years later in September 2020, only 3 months before the lawsuit. By the way, Ripple was first informed XRP's a security less than a month after. Huge, and he puts up this consensus.net article here. Hey, this is crazy. This is literally what we're dealing with when it comes to this lawsuit. I mean, obviously we're servicing them in their own words and their own actions. So it's like this isn't what Joseph Hall said. This isn't unfounded speculation or conspiracy theory stuff. It's like, okay, hey, things are starting to add up. You know, we're putting all the pieces together to this puzzle when it's almost complete. So coming over here, Digital Asset Investor was responding to Mr. Wells' tweet here where he says, just in BitMEX founders Arthur Hayes and Benjamin Dello have pleaded guilty to violating the U.S. Bank Secrecy Act. So he says founders of cryptocurrency exchanges pled guilty to Bank Secrecy Act violations. And then Digital Asset Investor goes, meanwhile, Joseph Lubin, who helped disguise well purchases in Ethereum ICO, continues to work on the release of his second security, Ethereum 2.0. And then he says, Gary Gensler, Hester Pierce, and Senator Heron Lee do nothing. And he has the eyeball emojis. Yeah, I mean, this stuff should make you like just cringe. It makes me cringe. I'm going to end on this. Johnny Deaton's responding to a Bitcoin Archives tweet here where he says, Bitcoin is faster, cheaper, and more efficient than Swift. And then he goes, March 12th, 2018, Brad Garlinghouse speaks publicly about Ripple using XRP to replace Swift. And then 4 years later, Bitcoin is faster, cheaper, and more efficient than Swift. So, I mean, quite evidently, there's been a narrative trying to push that narrative of Bitcoin, using Bitcoin. But in reality, it's like, okay, yeah, Bitcoin has its place. Obviously, I invest in Bitcoin. I value Bitcoin. So it has its place. But it's like, okay, we have better technology that's actively, you know, with Ripple and XRP, actively capable of, you know, replacing Swift one day. So I thought this was quite interesting. With all that being said, that's kind of the update that's going on now. We're going to continue to track what's going on within the SEC versus Ripple case, and I'll keep updating you. With all that being said, stay strong out there. Be safe.